Hi everyone, happy Monday morning. I am Carol Williams with Beyond the Soundbite, and we are here with another Monday morning edition of all things U.S. immigration. So, I like to dive right on in. First thing I want to talk to y'all about this morning are the H-1B and H-4 enhanced social media vetting that will begin today, December 15th. So what that means is Department of State, through our consulates, will be looking at all H-1B and H-4 visa applicants' social media history. So they are telling people that they should leave their social media, including their LinkedIn, on open. Many people have their social media on lockdown so that only their friends can see it. So the government has, essentially said it needs to be open so that the officers can look at it. What has happened as a result of this new policy change that a lot of folks that had December visa appointments scheduled in consulates in different countries, most significantly the ones that I've personally heard of have been those folks that have had appointments scheduled in the U.S. consulates in India. Their appointments have been pushed back in some cases to March, some cases to May, and I think I heard one instance of even June. And so these folks are already in country. They're already at home, waiting for their appointment, their interview, which they thought was going to be in a couple of days. So now they are there, some of them for 3 months, some of them for 5 months, some of them for longer. And they are there because they can't get back into the U.S. without a visa. That's why they traveled home in the first place, was to apply for, pick up a new visa, and then come back in. So this unexpected, unanticipated change, pushing people's trips out 3, 4, 5 months, has my in-house global mobility folks working overtime with line managers and folks in the C-suite to handle these business interruptions. And so they have been working with us nonstop, just trying to strategize, can folks work remotely? If they can't work remotely, how do they shift work around internally? So while the Department of State has made this sort of last minute policy change, and then with no notice moving out and pushing back visa applications because of their own operational challenges to implement something so quickly, it is definitely having a trickle-down effect, and it is absolutely impacting businesses. So my suggestion right now is that if you are an Indian national and you need to go home for a visa and you can hold off on that, I would recommend right now that you hold off on traveling specifically to apply for a visa until the consulates sort of figure out and have a better handle on the operational needs and challenges that they are currently experiencing with this, because nobody wants to be stuck for 3, 4, 5 months. So I will keep you up to date as we hear anything about this. Hopefully the consulates will get their internal operational challenges straightened out sooner rather than later, and we can at least have some more predictability in the timelines when it comes to visa scheduling, so that global mobility folks, line managers, C-suite, folks internal to the business units can better help plan and predict workload, cash flow, all the things. The next thing I wanted to mention this morning, we know that there were some immigration changes in the wake of the National Guard shooting in DC. So I wanted to kind of just remind you all of what those were. The restrictions include a halt on all asylum decisions. This doesn't mean that you can't apply for asylum. It just means that they're not making decisions, approving or denying right now. There is a pause on processing all applications for individuals who are from one of the 19 travel ban countries. So as a reminder, those 19 countries are Afghanistan, Burma, Chad, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. So if you are from one of those countries, it does not matter what application you currently have pending or what application you file. As of right now, there is a pause on processing those applications. And again, that doesn't mean that you cannot file them. If you're bumping up against a deadline, or if it's something that you qualify for, you can absolutely file. Just know that right now there is a pause on processing those applications. The U.S. Immigration Service will also be re-examining certain applications that have already been approved. So we'll see what that looks like. We don't have a whole lot of guidance on that yet. And there has been a suspension of visa processing for individuals who currently hold Afghan passports. So all of those policies, those policy changes came out of, or as a result of, the National Guard shooting in Washington, D.C. The $100,000 H-1B fee is still in play, it's still there, but we now have a third lawsuit against that $100,000 fee. This lawsuit is being brought by several states, 19 states in total. Some of those states are California, New York, Massachusetts, Illinois, New Jersey, Washington, just to name a few of them. And they are essentially arguing that the $100,000 fee is illegal because Congress ages ago determined that immigration filing fees were designed to cover the cost of administering of the programs that they are for. So hence your H-1B fee should be the fee that it costs to implement that specific program. Your fees for L's should be the cost that it takes to administer the L program, so forth and so on. So this lawsuit is alleging that it does not take essentially $100,000 per applicant to process H-1Bs. So we'll see. Essentially, the response from the White House for the other two lawsuits, and I anticipate their response to this third lawsuit, will be that the fee is going to help prevent fraud in the H-1B category. So I don't know what will happen with these lawsuits. My crystal ball has been a little cloudy lately, but I'll certainly keep you up to date on them. If we've got anything significant coming out of now 3 of the lawsuits, I will certainly keep you updated and let you know. Just the ESTA. Let's talk about ESTA for a minute. So ESTA is for individuals who are from countries where a visa is not needed to come to the U.S. to visit for vacation or short-term visits, right? So December 10th, just a couple of days ago, Department of State published a proposed rule that would really make some very significant changes and overhaul the application process for ESTA. Right now, you go online, you fill out a pretty quick application for ESTA. I've obviously never filled it out myself, but my clients have told me they filled it out. It's not, they haven't found it terribly onerous to do, but it's all done online, sort of a contactless application. So the new application, which they are proposing, all of this is proposed. This is not in place yet. It is all proposed. But they are proposing a requirement of a selfie, an actual selfie for the applicant to make sure that that is a real applicant. They would then use the geotagging in that photograph to make sure that it's a recent photograph. They want 5 years of social media history for vetting purposes. They want to take biometric data from ESTA applicants. They want 10 years of email addresses. They also want to collect information on your family members to include the date and place of birth of your family members. And they want 5 years of your business information, including phone and email. I've spoken to several folks about this, and there are some concerns that this information is being requested for folks that are essentially coming for short-term visits. So, and kind of read up a little bit on this and sort of seen some initial reactions. And some of the initial reactions include the following, that the tourism industry would be potentially negatively impacted. I've seen comments online that people just aren't going to hand over all of this information for a family vacation, business trips to the U.S. to meet with clients or attend trainings or attend conferences may potentially slow down from international visitors if they are required to present all of this information. Airlines, I've seen some comments where airline folks, it has been mentioned that airlines may want to be a little concerned about this. They may see fewer bookings during some, the peak holiday times to come visit the US, because back to the first comment, people just may not want to provide all this information for a family vacation or a short-term visit. And so all that to say, we'll see. It is proposed. They are accepting comments until February 9. So if you have some comments on this and you've got some thoughts, you're welcome, obviously, to send a comment to the Department of State, but you must do so before February 9th. That's when all comments are due. And again, this is really significant changes to the ESTA application and the information that is requested. And again, this is going directly to the White House's initiative on enhanced vetting and determining who is coming into the country, and what's, if they have a criminal background, that sort of thing. So we'll see what happens. I will keep you updated. Next thing I want to talk to you about are employment authorization documents. So different types of applicants are eligible for employment authorization documents. What we had seen was a split over time, an increase in the amount of time in which employment authorization documents, otherwise known as EADs, were valid. We were seeing this increase in their validity time because we were seeing a decrease and a slowdown in the time that it would take. We were seeing an increase also in the time that it would take USCIS to process EADs. So USCIS over time continued to increase the validity time of the EAD because they were not keeping up with the demand in sort of a timely way. So new policy change, any EADs issued, or the majority of EADs that will be issued after December 5th, will be valid for a shorter period of time. That shorter period of time will essentially go from 5 years to 18 months. So application types that are eligible to apply for EADs, where this will be impacted, are refugees, asylees, withholding of removal grantees, pending asylum applicants, pending adjustment of status applicants, and pending cancellation of removal applicants. So if you have one of those applications pending and you are also applying for an EAD, just know that your EAD will not be valid for the 5 years. It will, if it is issued after December 5th, it will be valid for only 18 months, and then we'll obviously need to just apply for an extension before the 18-month expires. So new policy process, not really a process, but sort of the end result is that your EADs will be valid for a much shorter period of time than we have seen recently. USCIS has announced a new vetting unit. They've stood up a new vetting unit. It is apparently headquartered in Atlanta. It will really kind of, I guess the purpose of it is to consolidate the enhanced vetting initiative. from the White House, so that, it's really sort of messaging is coming from one place out to all the various USCIS offices. So I'll keep you, updated on that. I don't honestly know that we're going to get a whole lot more in terms of notification on that. But we'll see. If I do, I'll certainly let you know. And the last thing I have for this Monday morning, I've had kind of a bit to talk about today, but the last thing I have is that we now have the form for the gold card. The gold card is where you pay $1 million to the U.S. government in order to, or I guess as part of your green card application. This is conceived of, this green card process is conceived of by the White House. So what we do know is that it is a fee, I guess the filing fee is $15,000, and the pay-in is $1 million. So I think the form and the instructions are about 25-ish pages. So lots of digital ink has been spilled on this thus far. I will keep you updated. I think lawsuits can be expected as it places these new gold card program applicants are taking green card numbers from the EB1 category. And so that was not part of the original concept of EB1 category. So I suspect we will see a group of EB1 folks who may sue and say that you're essentially taking precious numbers away from EB1 applicants. So we'll see. We'll see what we see on this one. But we're the government is one step forward with this particular green card program. So now we have a form, which every time you get a form, you get instructions. So I will keep you up to date on this as well. But in the meantime, if you have any questions, whether it's about the new gold card program, your EAD validity, potential changes in the ESTA overhaul, are you subject to the $100,000 H-1B fee? You're welcome to reach out to us. We are here to help you. So again, I'm Carol Williams with Williams Immigration. It's another Monday morning edition of Beyond the Soundbite. Have a great rest of your Monday and a beautiful rest of your week.